There are two legal battles unfolding right now, one in the Supreme Court and one in a federal district court, and they're about who counts and who commands and how power moves when the ground feels shaky. Let's start with the one that reaches back to the very meaning of citizenship. The Supreme Court is now considering whether to take up President Trump's executive order that tries to limit who qualifies for citizenship by birth. Specifically, it would deny citizenship to children born on U.S. soil if their parents are undocumented or here on short-term visas. And multiple lower courts have already blocked this order, including a major class action case and a Ninth Circuit ruling this summer. But now it's up to the justices to decide whether they'll step in or leave the existing blocks in place. The heart of the matter goes back to 1898. When the court ruled in United States v. Wong that the 14th Amendment guarantees citizenship to nearly everyone born on American soil. There were narrow exceptions like diplomats and enemy occupiers, but otherwise, that promise has held for over 125 years. And this new dispute asks whether that guarantee can be redefined, not by Congress or constitutional amendment, but by executive order alone. To the second story, which is playing out in Washington, D.C. Yesterday, a federal judge ruled that the Trump admin and their months-long deployment of the National Guard in the Capitol was unlawful. She stayed the order for 21 days, giving the government until December 11th to appeal. The Guard has been in D.C. since August, with about 2,000 troops deployed, including roughly 1,000 from other states, and brought in without any formal request or consent from the city. The admin said it was for public safety, of course. But Judge Gia Cobb said there was no clear legal basis for that kind of deployment. No invocation of the Insurrection Act, no statutory authority for using troops to deter general crime, and no justification for bypassing local autonomy. This isn't the first time we've seen tensions over domestic troop use. In 1957, President Eisenhower sent federal troops to enforce school desegregation in Little Rock. But he did so with a specific court order, and a statutory mandate, and a narrowly defined mission. That's the difference. Clear legal ground versus open-ended deployments. So in one case, we're asking, who gets to belong here? And in the other, what are the limits on the president's power to bring military force into our cities? And at their core, both stories are asking whether the Constitution still acts as a boundary, not just a symbol. In the coming days, the Supreme Court could announce whether it will hear the citizenship case. And if no higher court steps in, the Guard presence in D.C. could begin to wind down after December 11th. These aren't just legal flashpoints. They're stress tests for a republic under pressure. And they're worth watching closely, because when power tries to redraw the lines of identity, of authority, of consent, it falls to the people and to the courts to decide what holds. So here's the question I'll leave you with. In a moment like this, how do we uphold both? Firm limits on power and a generous definition of who we are.